This evening, I want to walk you through what is actually documented about the Trump financial picture, what the real court filings show, what the genuine disclosure documents reveal, and what the authentic brand and licensing story looks like when you strip away the fabricated drama that keeps circulating on social media. Because the real picture is complicated enough, consequential enough, and genuinely significant enough that it does not need embellishment. And understanding it requires looking at primary sources rather than theatrical YouTube narratives designed to sound like insider knowledge. Let's start with the civil fraud case, because it is the legal proceeding that generated the largest headline numbers and also the most confusion about where things actually stand. In February 2024, after a trial that ran from October 2023 through January 2024, New York State Supreme Court Judge Arthur Engoron ordered Trump, his company, and co-defendants to pay approximately $454 million in penalties, a figure that grew to roughly $500 million with accruing interest. After finding them liable for business fraud involving the systematic inflation of asset values on financial statements used to secure bank loans and insurance arrangements over a decade. That judgment, which generated enormous coverage, was the number the fictional scripts have been recycling ever since, as though it were a currently active financial obligation. Here is what actually happened next, and it matters enormously for understanding the real situation. In August 2025, a New York appeals court issued a 323-page opinion in which all 5 judges agreed the $500 million penalty should be thrown out. 2 judges found Trump properly liable for fraud, but ruled the fine was constitutionally excessive under the 8th Amendment. 2 other judges said the trial court had erred and the case should be retried. A 5th judge argued the Attorney General should not have brought the case at all. The fraud liability finding was technically upheld, but only because 2 of the judges who wanted a retrial joined the court's order to avoid deadlock and ensure a final decision. The court maintained some business restrictions on Trump, including court-appointed monitoring of the Trump Organization's operations. New York Attorney General Letitia James announced she would appeal to the state's highest court, the New York Court of Appeals, to restore the penalty. Her statement noted that multiple courts had now affirmed Trump was liable for fraud, even as the monetary remedy remained disputed. It should not be lost to history. Yet another court has ruled that the president violated the law and that our case has merit, James said. That appeal is pending. The injunctive restrictions on how Trump and the Trump Organization conduct business in New York remain in place while the appeal proceeds. The enormous financial penalty, however, is not currently being collected and is not an active cash flow obligation. That distinction matters enormously for any honest analysis of the organization's current financial position. Now let's look at what the actual financial disclosure documents show, because this is where the real Trump business story becomes both more interesting and more legitimately concerning than the fictional version. Trump's first public financial disclosure of his current term, covering the 2024 calendar year and filed in June 2025, reveals gross income exceeding $600 million from a portfolio that has shifted dramatically in its composition. The disclosure shows $217.7 million from Florida golf resorts, including properties in Jupiter, Doral, West Palm Beach, and Mar-a-Lago. Foreign branding deals yielded over $36 million from projects in Vietnam, India, and Dubai. Additional licensing and royalty income came from branded merchandise, including watches, sneakers, fragrances, NFT trading cards, and a Greenwood Bible. The most striking figure, however, is crypto-related. Trump reported $57.4 million from his ownership of governance tokens in World Liberty Financial, the blockchain firm co-founded with his sons, and a separate $320 million from the Trump meme coin launched in January 2025 through associated transaction fees. To put that in context, the traditional licensing business, The watches, sneakers, fragrances, bedding, merchandise that the fictional scripts describe as having collapsed represents a relatively small portion of the actual financial picture in 2024. Reuters constructed estimates combining Trump's public financial disclosures with property and court records and cryptocurrency transaction data, and found that traditional business lines generated more than $600 million in 2024, while crypto token sales produced $57 million in late 2024 and $618 million in the first half of 2025 alone. Let that number land properly. The Trump family's cryptocurrency ventures generated an estimated $618 million in the first half of 2025, more than the entire traditional business empire generated in the previous full year. Reuters reported that based on official disclosures, property records, financial records from court cases, cryptocurrency transactions, and other sources, the Trump Organization's revenue surged roughly 17-fold in the first half of 2025, from $51 million a year earlier to approximately $864 million, with over 90% of that coming from cryptocurrency projects. This is the genuine financial story. And it is not the story of a brand collapsing under commercial pressure. It is the story of a financial empire that has pivoted dramatically and lucratively from traditional real estate and licensing revenue into cryptocurrency ventures that are generating revenues at a scale the old licensing model never approached. And that pivot is where the legitimate documented concerns actually live. Trump launched the Trump and Melania cryptocurrency tokens in January 2025, shortly before taking office, attracting billions in speculative investment. Watchdog groups immediately raised concerns that the tokens provided a mechanism for foreign buyers to direct money to Trump-affiliated entities, since Trump-associated companies owned approximately 80% of all tokens and stand to benefit directly when the price rises. The mechanism is not subtle. Foreign individuals or foreign government-linked entities that want to generate goodwill with the American president can purchase tokens, the value of which flows largely back to Trump-affiliated holding companies. The conflict of interest concerns became concrete and documented in April 2025, when a website connected to the Trump family announced that the top 220 investors in the Trump meme coin would be invited to a private gala dinner with President Trump at his golf course outside Washington. The top 25 buyers would receive FaceTime with the president at an exclusive VIP reception before dinner. The top 4 investors would receive a limited edition Trump-branded watch. Congressional Democrats sent a letter to the Department of Justice characterizing the arrangement as a potential violation of the federal bribery statute and the Foreign Emoluments Clause of the Constitution. The World Liberty financial arrangements raised even more pointed concerns. Days before Trump's second inauguration, Sheikh Tahnoon bin Zayed Al Nahyan, the UAE's national security advisor, purchased a 49% stake in an entity connected to the venture. Following that transaction, the Trump administration subsequently loosened export controls that had previously prohibited the transfer of high-end AI processor chips to the UAE, moving from a presumption of denial to case-by-case review. Critics, including foreign policy analysts, argued the timing raised serious questions about whether American national security policy was being shaped by the president's personal financial interests. Senate Democrats introduced resolutions characterizing what they described as structural emoluments violations, distinct from the more incidental conflicts of the first term, where the concern was primarily foreign diplomats booking hotel rooms. The 2025-era concerns involved direct contractual relationships with foreign sovereign wealth funds, timing of Vietnam trade license arrangements relative to tariff reductions, and cryptocurrency purchases by Abu Dhabi-linked entities. The Trump Organization's stated position on all of this is consistent with its posture during the first term. Management of assets has been delegated to the president's children, an outside ethics lawyer monitors the company's activities, and the organization will not enter new material transactions with foreign governments and will donate foreign government patronage profits to the U.S. Treasury. Ethics experts have consistently said this arrangement, essentially unchanged from the first term, does not adequately prevent conflicts between the president's official duties and his business interests, particularly given the new cryptocurrency ventures, which did not exist during the first term, and which operate with significantly less transparency than traditional real estate or licensing agreements. Now let's look at the traditional licensing business honestly, because that is where the fictional scripts do have a kernel of reality worth examining. They just dramatize it beyond recognition. Trump's 2024 financial disclosure showed licensing and royalty income from two LLCs, including approximately $7.2 million from an NFT licensing agreement with the company selling digital trading cards. That figure was up sharply from roughly $300,000 in the previous disclosure. Foreign licensing deals, including internationally in Vietnam, India, and Dubai, contributed over $36 million. These are real numbers. The merchandise licensing business, the watches, sneakers, branded goods, exists and generates real revenue. But the scale is nowhere near the hundreds of millions the fictional scripts describe as having been simultaneously terminated. In 2022 disclosures, Trump reported approximately $30.4 million in licensing fees and royalties, $26.5 million in management fees, and $537 million in golf and hotel income. The brand in traditional commercial markets has faced real challenges. Documented departures of corporate tenants from Trump properties after January 6th, the PGA Tour relocating championships from Trump courses, reduced international corporate event business at Trump hotels during and after his first term. These are real business impacts that appear in property revenue figures and occupancy data. But they do not remotely resemble the coordinated simultaneous termination of 17 licensing categories by Fortune 500 companies under morals clauses that the fictional version describes. The Trump Media and Technology Group, which holds Truth Social, adds another layer of genuine complexity to the financial picture. Trump holds a 53% stake in the company through a revocable trust overseen by his son, Donald Jr. The stake's paper value fluctuates with the share price and has at times been estimated at several billion dollars, making it theoretically the largest single component of Trump's net worth. However, the company generates minimal operating revenue, and its valuation is driven almost entirely by its political association with the president rather than by underlying business fundamentals. Here is where the full picture lands when you look at the actual documents rather than the dramatic version. The Trump financial empire in 2025 and 2026 is not a collapsing brand being abandoned by licensing partners under morals clauses. It is a business that has undergone a genuine structural transformation, pivoting away from traditional merchandise licensing and real estate toward cryptocurrency ventures that are generating revenues at a scale the traditional business never achieved, but doing so in ways that raise documented, serious, and legally substantive questions about conflicts of interest, constitutional compliance, and the use of presidential power for private financial benefit. The constitutional checks that would normally constrain these arrangements have largely failed to function in practice, according to legal analysts who have reviewed the documented transactions. Senate resolutions condemning specific arrangements have been introduced, but have not advanced in the Republican-controlled Senate. The courts, which are the other venue where these concerns would normally be adjudicated, face the practical obstacle that the president himself is a central witness and party to proceedings that would be difficult to conduct while he holds office. What the documents actually show is not the story of market-based accountability disciplining a toxic brand. It is the story of a brand that has found new and more lucrative revenue streams through channels that are less transparent, more constitutionally fraught, and more directly entangled with foreign government money than anything that existed before. The morals clause narrative is fiction. The conflict of interest concern is real, documented, and backed by court filings, disclosure documents, congressional letters, and constitutional analysis, none of which require fabricated certified mail, invented docket numbers, or fake Warren Buffett quotations to make the case. The documents speak for themselves. They just require actually reading them.